Your Honor, I have Senate Bill 1446. Senate Bill 1446 is a bill. It's a version of a bill that I put in last year. For some reason, it got sent to Ed and Health and got sent off to have a discussion over the summer, which we had. And this is a recurring problem this body's been trying to deal with for a decade or more. Basically, the idea of the bill is to try and deal with treating medical doctors who refuse to speak to attorneys who are representing their patients. And so just to give you all a little bit of context, when somebody gets hurt, they go to an emergency room, they get treated, they come out, they end up going to some other doctors, et cetera. And if you end up deciding to try and make a personal injury claim about it, then you have to put in writing what the doctor's opinions are going to be to the other side. And in the medical records, the doctors often don't say, in the records, what they say is, the person came in, they had this problem, I treated it, it got fixed, whatever. But they don't often say what the cause of the problem was. In order to designate your opinions to the other side, when you're litigating, you got to tell them what the cause of the opinions are. And in order to do that, you have to talk to the doctor to make sure the doctor believes that the car accident or the slip or the fall or whatever it is that occurred caused the injury they're treating. If you put in there that the doctor believes they were caused and you didn't talk to the doctor, you can get sanctioned. The lawyer can get sanctioned in order to pay the other side's fees. And I would say the majority of doctors are happy to talk to you, especially if you pay them their hourly fee, which is usually like between $500 and $1,000 an hour in my experience. But there's some doctors and some health systems where the doctors just refuse to return phone calls. They say, I don't talk to lawyers, I'm not talking to you, I don't care if they were my patient or not, I'm not talking to you. And it creates a huge problem for everybody because, number one, the only way to present that evidence to a jury is you got to go out and spend $5,000, $10,000 and have a forensic examination done of your client. Or alternatively, you can subpoena the doctor to a deposition, which costs, $2,000 to $5,000. And if the doctor gives testimony that is contrary to what your client needs, the defense will then subpoena the doctor to trial and just create a defense witness. And it creates a lot of time and expense and unnecessary wheel spinning. And so basically what the bill does is it says in paragraph 1 that the doctor has to have a fee schedule for talking on the phone, for doing depositions, for testifying at trial, and they have to provide the fee schedule upon request. Number 2, it says that if a lawyer or a life care planner would like to speak to the doctor, that they're required to set up a telephone conference, a phone call or something within 14 days of a request, provided that the lawyer has paid them in full, in advance, before the meeting, and that the doctor and the lawyer is certified they're not investigating malpractice. Paragraph 3 basically says they have to give you deposition dates within 60 days of a request, and they have to attend the deposition provided they're paid in advance. And 4 has to do with them providing an estimate of what their future services are going to cost. And subsection B basically says that if there's an emergency and they have to cancel, that they can do that. Mr. Chairman, I also have 2 line amendments that Ms. Walsh has prepared.
Okay.
One line amendment was requested by the Virginia Society of Orthopedic Surgeons, and that basically says that if the attorney cancels a meeting or a deposition within 14 days, that the fee is non-refundable. And the second provision is a new subsection C, which creates an enforcement remedy. It says that if a doctor doesn't comply with this statute, a court can fine them up to $1,000 per occurrence and award attorney's fees. And Ms. Walsh has actually prepared the amendments. Okay. I would move them.
Is there a second to the amendments, the line amendments? Is there a second?
Yes.
Okay. All right. It's been seconded. All in favor of the motion and the amendment to adopt the line amendment, say aye.
Aye.
All opposed? All right, motion carries.
Mr.
All right.
Chairman?
Senator Morrissey.
Scott, let me ask you this. With the exception of providing a fee schedule upon request set forth in paragraph 1, isn't all of this already being done? And I'm trying to understand the genesis of this bill because most doctors, every one of your items says pay them in advance for the telephone consult, for the deposition, et cetera. Are they not currently doing that?
No. So here's the problem. some doctors just say, I don't talk to lawyers. My office doesn't talk to lawyers, or they say my system doesn't let me talk to lawyers, or, if you want me, take my deposition. That's all I'm doing, right? Which is the most expensive, clunky way for everybody involved to deal with it. So, and also, I just want to give you some context. This fight arose about 15 years ago, and it resulted in the Virginia Bar Association assembling a meeting of the trial lawyers and the defense counsel, whatever, and they published like a 10-page statement of principles of cooperation, and they hoped that by publishing this, everybody would just get along. You know what? It didn't work. And so about 5 years ago, I put out a request on a trial lawyer listserv and said, how many people have this problem? And actually, I wish I had brought in it. Almost 80% of the trial lawyers that responded said they have this problem, doctors not returning phone calls. And I have story after story after story. Then I reached out to Scott Johnson with the Medical Society and said to him, how can we fix this without doing a bill? He said, send me all the doctors' names who won't meet. I'll try and work with you. I sent him 20 names of doctors. He called each one of them up and said, stop refusing to meet with lawyers, stop refusing to meet with lawyers. I would say about 2/3 of them, maybe 3/4 of them, stopped doing it, including a couple big practices. But there was a few of them that just said, I'm not doing it. I don't care what you say, make me. Okay? And so after playing ombudsman for like 2 years, I finally said, forget it. There's a couple of systems that just aren't ever going to change. We have to do legislation. And so by putting in this bill last year and having further conversations, I'm happy to say there's 1 or 2 systems that have now told me they're going to change their practice, but there's still multiple doctors out there that just will not speak to lawyers because they just say, I don't want to be bothered with it. And so this bill just creates a structure which makes it easier for everybody and saves everybody time and everybody money. And I really don't know what the concern could be by saying you have to have a phone call within 14 days of request and you have to arrange a deposition within 60 days of request and you're going to get paid in advance.
Right. Mr. Chairman, final question.
Yeah, Senator Morrissey.
I agree that it's practical, it's purposeful. What is the Medical Society saying?
Well,
they don't. This medical. I believe you'll hear from them in a second. And actually, this language was drafted by them, and we were within like 12 hours of a committee presentation. And I thought we had a deal, and then they withdrew it last year after some members started to complain to them. So they're officially opposed to it. But okay. I believe the orthopedic surgeons, who probably are at least half of the doctors that get involved in this, I think they're okay with the bill now as I've rewritten it.
All right.
All right, let's hear from the public, okay? Mark Dix.
Good morning, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association, and we support the bill. We thank Senator Surovell for bringing this important piece of legislation forward. As Senator Surovell mentioned, this is a problem for a number of our members, particularly in Northern Virginia, with doctors who just won't respond to letters, calls, or emails. And I know we probably could have titled this the Senator Surovell and Scott Johnson Relief Act as well, because I know that they're tired of being ombudsmen for these types of issues. We believe this is narrowly tailored, and this provides a good rule book that we can all live by, because the principles of cooperation have just been utterly toothless. And we hope it'll be the pleasure of the body to pass the bill. Thank you.
Speaking of Scott Johnson, would you like to say something?
Good morning, Mr. Chairman. Scott Johnson, speaking as General Counsel for the Medical Society of Virginia. Senator Surovell is correct. The Medical Society leadership voted to oppose this, and we have devoted a lot of time to talking and trying to work with him, and I appreciate his outreach. He didn't have to do that, and we don't take that for granted. But we are concerned that this bill basically would mean discussion stop, and there has been progress. We had a Zoom meeting on August the 5th where we got the stakeholders together, and there's been some progress, so it shows talking works. I would also point out this bill is not just written to physicians, it's written to all providers as well. And I would also note, I just saw the Second Amendment that Senator Surovell mentioned there, and it's interesting that the penalty side of it is one-sided. You're putting the burden on the providers, but giving the attorneys a get-out-of-jail-free card if they don't comply with it. A number of groups also wanted to speak today, and Mr. Chairman, for the convenience of time, if I may just read the list of other associations who are opposed to this. The Virginia Association of Clinical Nurse, American College of Nurse Midwives, Acupuncture Society, Virginia Association of Behavioral Analysis, Virginia Midwives Alliance, Virginia Association of Physician Assistants, and the Virginia Nurses Association. Thank you.
Okay, thank you. Brent Rawlings.
Yes, Mr. Chair. Mr. Chair, members of the committee, Brent Rawlings with Virginia Hospital and Healthcare Association. We are opposed to the legislation. Senator.Surovell is correct. We did have one meeting this summer, August 8th, I believe it was, during the pandemic, a few days before we entered into this special session. And then soon on the heels of that had the largest surge in COVID-19 cases yet. So it's been a very busy summer. We have agreed to work on this. We do believe in facilitating cooperation between healthcare providers and attorneys. However, this legislation as introduced is very heavy-handed. That's a classic case of the bad apple spoiling it for the whole bunch. Primary concern here is the time frame for responses and the regimented approach that it includes. Also, the fee schedule component and the cost estimate requirements are unworkable. We've had several conversations in the General Assembly about fee estimates and the challenges involved, so it's not as simple as being suggested here. We essentially just think this creates a trump card for attorneys over the interests of patients. We're asking for a 14-day time frame. A lot of people can't get in to see their physician within 14 days, so we need to strike a balance here. We're willing to continue to have those conversations, and we hope that you will oppose this legislation.
Okay, thank you. Christopher West.
Thank you, Mr. Chairman, members of the committee. Christopher West with Kaiser Permanente. We're the nation's largest private integrated healthcare provider. I would just associate ourselves with the remarks of Mr. Johnson and Mr. Rawlings as opposed to this legislation. This is just a heavy-handed mandate on our providers right now that are busy dealing with COVID and trying to defeat this pandemic. And so we would strongly want to continue our conversations to work out a resolution on the bill and hope that you would defeat it today.
Okay, is anybody else would like to speak? Okay, you've heard the bill.
Mr. Chairman.
Yes, Sen.Surovell.
This conversation's been going on for 15 years, and talking about another 12 months ain't going to do anything, okay? The doctors aren't going to agree to anything in the code, period. They don't want us telling them what to do. I don't understand what is so hard about saying 14 days to have a phone call and 60 days to set a deposition if you're going to get paid.
How about this?
Can I?
Senator Peterson.
How about if they agree to participate, then they'll still be subject to the med-mal cap?
Okay. All right.
Voluntary registration.
Okay.
Mr. Chair.
All right, Senator Obenchain.
Yeah, let me just point out, I don't know where this is headed, but it is maybe a little bit more complicated, and I have sympathies on both sides, but I also know that part of the difficulty that some attorneys have in getting cooperation from certain healthcare providers is the way that the hospital they work for operates. Yeah. And, you know, I've had many issues with doctors who've told me, look, nothing personal, but the hospital that I work for, you know, they charge you these fees. They make me do this on my own time, and I get paid nothing for it. So it's a little bit my silent protest that I'm just not talking to lawyers. And it's not necessarily the doctor's fault. You know, it may be, you know, the hospital policy as well. So, I mean, it's a complicated, challenging, difficult issue.
Mr. Chairman.
Senator Morsi.
A couple of comments and observations. I frequently find myself siding with the medical society and the hospitals in these matters, but I think I'm going to be hard-pressed to find a more common-sense piece of legislation in this session. First of all, with regard to one of the comments made that this is that ends the discussions. Sen.Surovell is right. The discussions have gone on long enough. There's no agreement. Number two, one of the people opposing it said this essentially gives the attorneys a get-out-of-jail card free. It does nothing of the sort. You read the legislation, they've got to schedule a phone call. They got to pay the doctor in advance. They got to schedule the essay deposition. They got to pay the doctor in advance. And third, the individual that referred to this being heavy-handed, this legislation is heavy-handed and defaulted to, we've got too many other things to do to deal with COVID. Nonsensical. I think the patron is is correct. They have worked tirelessly to get to some type of agreement. Nothing has worked, and now it's time to do legislation, and I think it is fair, it's purposeful, it protects those patients who are trying to receive compensation and their attorneys simply can't get in touch with a non-cooperating doctor. So for that reason, I'm going to move to report.
I'll second that.
It's been moved and seconded to report. I'm hearing differently from the doctors and the hospitals that they're willing to continue working on this.
Too late.
And I don't think it is too late. If people were willing to work on it, I think they should. So I'm not going to support the bill. If there's anybody else want to send it to the Civil Law Subcommittee for the year, like we did the other bill? Not hearing anything. Okay. There's a motion to report the bill. Any further discussion? All in favor of the motion, vote aye.
Senator Norman, how do you vote?
That's a mix-up.
Senator Norman votes no. Check. Ayes 8, noes 6, 1 abstention.
Wow, okay.
8 to 6.